recorded the copy. Record judgment thing.
So these are the three judgments which have been.
Points.
These have been considered in the by the learned court trial. These have been considered straightforward. I will invite to the order pathway for my.
You just formulate your point and then.
Only thing I will be harping upon is that whether there was a mental intent to that extent demonstrating 278E and whether my signature was there, that has been proved out. These are the 2 points I will be harping on. Because now it's almost more than 20 years. I have also grown old. I have become now 69 years. And the minimum sentence is 3 months.
We have no mercy for economy.
I understand. And even after
we go by the letter and spirit.
Naturally, and 292 is there that I cannot even pray for probation of offenders act. Straightforward, I'll just invite to page 30 of the page 30 That is the order passed by the learned trial court. May I praise the only 3-4 paragraphs I'll just like to place where my defense has been taken and not considered. I'll invite to my defense the finding which has been recorded para 8. Para 8 and 9 subject to may I place the prosecution story also?
I've read it.
Then kindly have a glance to the finding which has been recorded onwards after para 7 Para 5 was my case in nutshell, where I have stated that the case of the defense is of total denial of the offence as ignorance relating to illiteracy in committing. After recording this statement,
para 7 of the trial court judgment.
Trial court judgment.
Para 7 is something
finding
in order to establish.
That is what I am also placing.
In order to establish the
in order to establish
yes.
Prior to that, once the notices under 277 was issued to me, I had taken the same stand and that has also been considered in while narrating the prosecution story. Now coming on to the finding, in order to establish the charges, these things have been done in paragraph 8. On the other hand, I am placing para 8. On the other hand, defense has neither examined any witness nor has proved any documentary evidence to disprove the charges leveled against the accused person, nor any document has been brought on record for consideration of the court. However, the learned defense counsel pleaded complete ignorance of the accused and has strongly argued that the accused never signed in English and knows to sign only in Bangla, and has submitted that considering the absence of animus on the part of the accused, ignorance of the provisions of the income tax coupled with the contradictions in the testimony of the witnesses and non-examination of the sanctioning authority, the prosecution has not been able to prove the charges leveled against the accused person beyond the shadow of all reasonable doubts, and hence the prayer that the accused is entitled for acquittal. Coming to the evidences where the discussions have been made, this is para 9. Coming to the evidences of prosecution in the instant case and taking up the evidences of the complainant who has been examined as PW2, Vijay Bhaskar, who being the complainant of the case, has set the law in motion by filing the complaint petition alleging inter alia that the accused Reena Rai has claimed refund on the basis of the forged paper about which he had reasons to believe that they were not genuine, but despite such knowledge, in order to evade tax liability and to claim false and ungrounded refund on the basis of the forged paper, used the same and consequent thereto the furnished false and fabricated statements in and towards verification of the income tax return marked Exhibit 2. The witness has deposed during his examination in chief as PW2 that the accused Reena Rai was an assessee in his office while he was posted as income tax officer in income tax ward number 2 of Dhanbad, where he was posted in the year 2003-04. The accused Reena Rai has filed her income tax return for the assessment 2002-03 in his office by signing it, and the return was identified and proved by the witness, which has been marked as Exhibit 2. It is further evidence of this witness that by signing verification, he has claimed a refund of Rs 52,680 and in this regard has produced computation of income, receipt and payment account certificate relating to the house loan issued by the Bank of India, LIC receipts etc., The TDS certificate in the signature of BN Namta branch so-and-so Chirkunda was marked as Exhibit 3. The witness has further supported that the branch manager BOI Chirkunda has sent the letter regarding the housing loan amount and has stated to be a non-existent. He has also supported the fact that they have received letter from LIC and the show cause notice issued by the department under the signature of Kaushalendra Prasad was marked as Exhibit 4 on the identification and proof. The reply given in the signature of accused Renara was marked as Exhibit 5 on the identification and proof. This was the reply in 270C. He has also supported the fact that he was authorized to file the instant complaint, and since the accused has given wrong verification in his return, the instant case was filed. The complaint petition is marked as Exhibit E6 on the identification and proof. The witness, being the key witness, was cross-examined at length and has stated during the course of his examination that he personally do not know the accused Renara. He has also admitted that he is not aware as to how many languages accused Renara knows. The witness has also admitted that in the income tax return, the mailing address of A.K. Chatterjee has been mentioned and a number of cases were instituted against his A.K. Chatterjee. This witness has further admitted that there are a number of cases pending against Satyavan Roy also. The witness has also admitted that in reply to the show cause notice, the accused has put her signature in Bangla and except in the income tax return in Form 7. Nowhere signature in English have been made by the accused. The witness was further stated that the sanctioning authority was informed about Satyavan Rai, against whom also case has been instituted. He has also stated that there is no certificate on the complaint petition that it was typed by the witness. It is the further evidence of the witness that he has got no information that the accused Reena Rai knows only Bangla. The witness has denied the suggestion given on behalf of the defense that the accused has been falsely prosecuted and she has never signed the verification on the return. Apart from this witness, PW1 Balram Kumar Mandal is the stenographer attached with the commissioner. Because he is in relation to the sanctionment order. I am not questioning that part because there is a judgment of the Honorable Apex Court also that I have examined. And so far this part is concerned, I am only on to this aspect. Whether my signature was put was there on the form itself and it was verified by the authorities or not. That is the only question.
Did you file a response to the showcase?
I filed a response to the showcase 270.
You own it or you disown it?
I disowned it. That has also come in.
You disowned the reply also?
No, I disowned it. No, I don't do it.
You see your reply?
Milos.
Did why आपके पास? You have got the copy?
No,
of
Milos,
your
I
reply?
did not.
Show it. Read it loudly, please.
Milos.
What stand have you taken in the showcase?
Milos. Being asked to show cause as to why prosecution case should not be initiated against the petitioner for false declaration statement in the return. In this regard, the petitioner submits as follows: that the petitioner is totally aware of that the petitioner is totally a housewife and is having no other income but earning out of sewing and embroidering works. That the petitioner has put her signature on the blank returns form at the instance of Sri
So
Satyavan.
therefore, your signature in the return form in your show cause reply is also not denied. Right? Now you cannot say that I did not understand English and I signed it.
Plus para 2 and 3 is to that extent.
That's
and there is one
sufficient.
judgment also which
That
the
is
learned
sufficient.
trial court has taken into account that
That is
any prudent
sufficient.
person.
That is sufficient. Nothing more is required.
That is there. Only to the extent.
Blank papers, one can sign.
Plus that Magna judgment. Mangatram and Magna judgment takes care of that. No. That judgment is also the supreme, that has been taken into account. Grazim Industries, Because the learned trial court has considered that part. Para 5 of the judgment.
On the face of the reply that you have filed, no judgment is required to be signed. As simple as that. Isn't it?
Certainly.
Forget about the judgments. Likhiye. Criminal Revision number 1401 of 2016. The learned counsel for the petitioner, while assailing the impugned judgments, has submitted that the impugned judgments are perverse and call for interference. He has submitted that his argument is confined to 2 points. A, whether there was a mental intent on the part of the petitioner
278E
within the meaning of section 278 capital E of the Income Tax Act, and whether the signature of the petitioner has been proved or not. The learned counsel, while referring to the trial court judgment, has referred to paragraph
7 and 8
7 and 8 has referred to
Nine,
paragraph
nine.
8.
8 and 9.
8 to submit that the specific case of the defense was that the petitioner does not know English. She knows only to sign only in Bangla and was not aware about the provisions of income tax, coupled with, and there was contradictions in the testimony of the witnesses.
And the animus was not there on the.
The learned counsel submits that there was no element of animus in the matter. Rather, the learned counsel appearing on behalf of the petitioner has also submitted that the petitioner having completely denied her signature on the return, her signature on the return itself could not be proved. The learned counsel appearing on behalf of the income tax department has opposed the prayer and has submitted that every aspect of the matter has been taken care of. He submits that the petitioner had filed returns and the verification clause was signed by her. The return was marked as Exhibit 2 and she claimed refund of rupees 52,680 on account of some claim under housing loan and some income derived from LIC. Some TDS certificate on the basis of income derived from LIC. The learned counsel has submitted that the reply filed by the petitioner pursuant to the notice issued by the income tax department was marked as Exhibit 5 and the document is an admitted document from the side of the petitioner, and the petitioner herself has taken a stand that she had put her signature though on blank return form. The learned counsel has also submitted that in the reply she had taken a stand that she had done so at the instance of one Satyaban Roy and one and one A.K. Chatterjee. The learned counsel submits that the signature in the return form stands admitted. He has further referred to the provisions of Section 278 capital A of Income Tax Act and has submitted that the said provision has been taken into consideration. There is a presumption in connection with the mens rea in the matter of
278E, Milords.
278E, and therefore that has been quoted also.
That is there in the judgment itself.
At page 37 of the
Milords.
36 bottom part and 37 first part.
36 bottom, 277.
Scan. That was corresponding. It is there.
Yes,
Page 20.
page 28.
20.
We have submitted that the said provision has been quoted in the appellate court's judgment and no material was put forward by the petitioner to dislodge the said presumption. Rather, the petitioner was in a state of complete denial before the learned court, although in her reply she has not disowned the filing of the return, inasmuch as she did not deny that she had signed the verification form. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that as per the prosecution case, the petitioner had put her signature on the verification form and had filed false returns and wrongly claimed refund of rupees 52,680 by showing that she was having income from LIC and by furnishing TDS certificate, and that she had taken housing loan. Upon verification, these documents were found to be forged, and consequently a show cause notice was issued to the petitioner, wherein she did not deny her signature in the verification form. And stated that she had done so at the instance of two other persons, Sri Satyaban Roy and A.K. Chatterjee. However, being dissatisfied with the show cause reply filed by the petitioner, the prosecution was launched, and before the court, she completely denied her signature also, and disowned the filing of the return. The learned courts have scrutinized the materials on record and recorded finding against her and held the petitioner guilty of offence under section 277 of Income Tax Act. This court finds that no perversity as such. This court finds that the learned counsel for the petitioner has not been able to satisfy this court with regard to any perversity in the impugned judgments, inasmuch as all the materials have been taken into consideration. The petitioner, on the other hand, never led any evidence, and courts have considered the provisions of section 278 capital E of Income Tax Act also to sustain the conviction of the petitioner. This court finds no illegality or perversity in the impugned judgments, and accordingly the same does not call for any difference. Dismissed.
This second matter is also related
Same.
to the same petitioner.
Same
Financial
story.
year. Financial year is only changed.
Same story sub this
थोड़ा सा amount खाली एक जगह बैठ लिखना है।
amount खाली second case का बताइए. I will add a few sentences
Well,
to whatever I
that
have dictated. The amount involved in this case is 52,680.
and because it is for the financial year, because the
Claimed refund of rupees 52,680. This is for financial year 2003-4.
3-4 because that 2-3 is that and 3-4 is this.
That's right. Next, please.
Item 3, Criminal Division 1417 of 2016.
Yes, petitioner.
Same story exactly the same.
Same story.
Yes.
Even if he is absent, we will decide the case because this case was posted today in his presence, right?
Yes.
What is his defense?
Only difference is that the ground 3, page 8 of the revision. The reply to the show cause has not been considered. And the prosecution has failed to establish its case before the appeal. And on ground 8, it prays for the
Just a
compounding.
minute. How many matters are there in the office of SPC?
4 more matters.
4 more
Yes,
matters.
yes.
See, it's the first
Hmm.
call. We'll pass it over for a few cases.
Yes.
एंड देन उनको जितने भी सारे केसेस हैं उनका नाम के साथ सीरियल नंबर के साथ द मैटर हैज़ बीन पास्ड ओवर द केस विल बी टेकन अप एट 11:40 ऐसा फ्लैश कर दीजिए ठीक है जस्ट वेट फॉर अ फ्यू
Certainly. It's 11:45.
11:45 because 12 o'clock we have another
All cases, let's see.
चारों केसेस में सेम काउंसिल है ना
निमाई चंद्र में अलग है, सुलोचना देवी में अलग
काउंसिल्स आर डिफरेंट
है। Yes.
No, no, Mr. Sanjay Prasad.
Same.
Same counsels are
Yes.
in all the cases
Yes.
SP Sinha
No, no, Mr. Sanjay Prasad.
in all the cases
Yes.
Okay. जो भी काउंसिल हैं ऑन रिकॉर्ड उनका नाम दिखाए जरा लिस्ट में कौन संजय प्रसाद ठीक है इनका नाम फ्लैश करें पास ओवर yesterday the council was there right
Yes.
okay.
Under heading for admission, item 7, Criminal Division 228 of 2018.
आप आइटम बता रहे हैं
Item 7. Along with item 8.
where are the parties nobody appears on behalf of the parties hold this case on next Wednesday Thursday in the supplementary cause list no further adjournment will be granted
Item 9, Contempt Civil 498 of 2024.
Your ladies, I am brief to short first. My senior counsel, Mr. Sanjay Biswal, has been dealing with this case. Just for one case, he is
Contempt.
on his legs in court number 14 years.
Passover matters will be taken up at 12, right? Because 12 o'clock we have some assignments. Yes, which case have you come for?
Okay.
This one? 11:45 will come. Yes, he has come.
Yes.
Yes. Yes, what is the status of the contempt? You have filed your compliance report.
My lord, I have 5 your lordship. Only your lordship difference, only your lordship slightly your lordship. We have already held, meeting was held with the officials of the department and JPSC, and it was decided that there is no requirement of amended requisition, and only advertisement is to be issued to accommodate the new candidates. My lord, the draft of the advertisement has already been prepared, but in the meantime, your lordship, the chairman has superannuated. Now it is to be approved by the commission, and thereafter your lordship it is to be published. My lord, I have stated your lordship that after appointment of the chairman, we will proceed.
My lord, as per the rule, my lord friend saying, as per the rule, in absence of chairman, if he retired or he is not available, in that case, a member of the committee of the JPSC can act. That is a rule.
No, you see, we will not go to such an extent. We have to
That
wait
has,
for
my lord, the cognizance has already been taken by the honorable division bench even for appointment of the working chairman.
So don't worry about it. We have to just adjourn it for a few days. How much time do you
My
need?
lord, it is expected, your lordship, in this month, your lordship, the chairman or working chairman.
We can post
Because-
it on opening Saturday. What was the direction issue?
My lord, to accommodate the candidates, your lordship, who have been appointed on compulsory ground in class 3 and 4 post, your lordship. That was the direction. The rule of the state government was passed, your lordship, and thereafter the direction was issued. And for that, your lordship.
Where is the order? Order in. Where is the order?
My lord, order is at your lordship, start your lordship.
Your last 3122.
Main order was passed by the division bench on 16/12/2022, and thereafter, your lordship will come to
No, we have seen that.
page 133.
We are posting it on the opening Saturday. Okay. The counsel for the parties are present. The counsel for the opposite party has submitted that the chairman of JPSC has recently retired and a new chairman is likely to be appointed shortly, and therefore he seeks adjournment. He submits that steps have already been taken for compliance of the order of this court. Post this case on 18th of October.
Ma-
The supplementary
In the
show
meantime,
cause,
it will be your lordship.
the supplementary show cause be filed by 17th.
Ma- All right.
1810.
My lord, sorry, I was in court number 7.
Good. It's good to see everybody busy.
From daily list under heading for finalist proposal item 1 WPC 668 of 2016 along with item 2, 3.
Are you there in this case?
In this case, there are 3 cases arising out of Chuta Nagpur tenancy of Amar Sinha sir was supposed to argue in WPC 668 of 2015.
See, if you have to seek adjournment, don't give so much of background.
Sorry,
So what do you want?
please.
You want adjournment?
Adjournment, no? Only for 2 weeks.
When do you want? It's a small matter, isn't it? Counsel for the petitioner seeks adjournment. Nobody appears on behalf of the respondents. Are you there for the respondents? I forgot your name, sorry. Now sorry. Sorry. Mr. Aishwarya Prakash, advocate, appears on behalf of private respondents.
No, madam, state.
On behalf of the state. Is there any private respondent?
Yes, ma'am.
Why are they not appearing? Notice has been served upon them. Nobody appears on behalf of private respondents. At the request of the counsel for the petitioner, the matter is adjourned. You just choose your date. Choose your date.
Minor. 27 September.
No, not this side of vacation, post vacation. 18th.
Minor.
18th you will be available?
Minor.
Are you sure?
Minor.
On 18th of October.
Item 5, Criminal Division 14355 of 2016.
Petitioner? Where is the petitioner?
Item 5.
Petitioner absent. By way of last indulgence, let this matter be posted on Thursday in the supplementary cause list. In case the petitioner does not appear on that day, the case will be decided on the basis of materials available on record. LCR added?
Yes, please.
The records from the concerned court has already been received. State is also absent.
Next.
Thursday. Supplementary cause list.
Item 6, Second Appeal 110/2017.
Yes, petitioner. Yes.
I'm for the respondent.
Where is the petitioner? Service report.
लास्ट डेट पर भी कोई एप्लीकेंट की तरफ से नहीं आया.
Kindly pass over 43 matters. Mr. S.K. Sharma is engaged in court number 7.
Counsel for the petitioner seeks adjournment. Post on 18th. Saturday को pass over नहीं हो सकता. There are so many miscellaneous matters posted. You ensure that he is available on 18th. Okay? Pass over नहीं मिलेगा. I'm telling you, on the next day, you ensure that your counsel is here to argue the case. Okay? 18th October नहीं हो सकता ना. There are so many miscellaneous matters on board.
नेक्स्ट डेट
Item 7,
18th.
Item 7, Criminal Division 313 of 2020.
Yes, petition.
May I pray, Balloon, that first the serial number 8 will be taken, Balloon. That is the first case before the trial.
Serial number 3.
Serial number.
What is the matter about?
Matter is, Balloon, the conviction is under section 498A of the Indian Penal Code, 3 years punishment. And the same has been modified.
No, this is
By
138. ये कौन सा आप केस कॉल आउट कर रहे हैं?
Item 7.
Item 7.
Item 7.
Yes.
Criminal Revision 313.
नहीं, गलत.
Where is the petitioner?
Lordship, on behalf of opposite party number 2, I take for short pass with Mr. Asim Kumar Sandhu will argue in this case.
The bail bond has been cancelled earlier, right? Where is the? Yes, you are there. You argue.
Yes.
What is your case? You note down the arguments. Let Mr. Sai come. You note down the arguments.
Yes, sir.
Yes. But yes, counsel.
Yes, my lord. Case of the petitioner in the complaint paid rupees 9 lakh to the petitioner with friendly loan on 21/8/2015, for which the petitioner issued 2 post-dated check amounting to the tune of rupees 5 lakh and rupees 4 lakh. First
The,
check was yes.
Okay.
First check was presented on 31/12/2015 for encashment. That is amounted to the tune of rupees 5 lakh, dated 31/12/15.
That what is the date of the check?
Check का date था.
Okay, it was presented on.
Yes,
It was
madam.
presented timely.
Yes,
right?
madam.
5 lakhs.
Yes, 5 lakh. And unpaid for the reason that drawer signature differ कर रहा था. So that the complainant for the petitioner thereafter, as per the complaint, the petitioner used and lost the loan amount in gambling. As per the complainant itself. Complainant का केस है कि petitioner हमसे पैसा लिए और ये gambling में हार गया पैसा. After demand notice, coming petitioner filed before the. Thereafter, my lord, petitioner was sentenced to undergo SI for 6 months and also directed to pay compensation of rupees 5,50,000.
That's right.
And thereafter, learned Court of District and Session Judge has also convicted.
So what is your point?
Yes, my lord. My point is, my lord, that one independent witness has been examined in this case. Only one independent has not fully supported the case of complainant. As such, learned court below should have taken adverse interest against the complainant. Second point, my lord,
He was a prosecution witness.
he was a witness of the complainant.
Prosecution witness.
Yes. Complainant has also not able to produce the bank document showing that he had the amount in the bank to disburse the loan in question. He has he has to show that I have this amount and I have power and I have a capacity to give a loan of huge amount, 9 lakh rupees. He has no bring on record the income tax return or other document. So he has violated the section 269 SS of Income Tax Act. As the loan of more than rupees 20,000 should be given only by way of account pay check. And the amount which was given to the petitioner, my lord, which has it is the case of complainant that he has used in gambling. So this is not a legally enforceable debt.
No, just
Yes.
the complainant.
Himself has admitted in his complaint.
Just a
petition.
moment.
Yes.
Complainant gave friendly loan.
Yes, my lord.
Friendly loan
Of rupees 9 lakh
to petitioner, which the petitioner used in gambling.
in gambling.
Okay? And therefore, this is for illegal purpose.
Illegal purpose which is not
Gambling is
permissible.
banned.
Yes, my lord.
Gambling is banned.
नहीं, not bank. Gambling ban है, yes, my lord. Gambling ban है. As per gambling which is illegal in India, and any action to recover any money which is prohibited by law and declared illegal cannot be maintained in the court of law. In cross-examination, the complainant states that he does not know as to in which business the accused engaged himself. Second thing, this is not a legally enforceable debt. Complainant has to prove that this amount which has been mentioned in the check is a legally enforceable debt.
That's all.
Thereafter, my lord. Yes, my lord. Complainant, one more ground, my lord. Family members are habitual of giving loan. Complainant and his family members are habitual of giving loan, that means they are uh, uh, doing a business of money lending without any license. As because habitual of filing complaint case before the court of law, that is C1 case number 159. There are 1, 2, 3, 4, 5. 5 cases has been filed against a different person without showing this amount into ITR. And by filing of case, he is trying to convert his black money into white money by playing fraud to the court of law. And on this point, my lord, I will submit my some judgment. I could not.
Adjournment rejected.
Yes, my lord.
Adjournment
Adjournment हम
rejected.
नहीं मांग रहे हैं, हम तो बोल रहे हैं कि हम जजमेंट हम दे देंगे इस पॉइंट.
कब दे देंगे?
दो पॉइंट परसों रोज था my lord. Day before yesterday it was listed. Thereafter I was not a file itself.
We are not. We will dictate the judgment.
Yes,
right
my lord.
now.
Yes, yes.
We will dictate the judgment right now.
Yes, you.
Place the impugned judgments.
Yes. Okay. Trial court judgment below. Page number 22, Annex 2.
That's right. Come to the finding.
Yes, my lord. Finding starts from page number 2, page number para 7, and it has been in the present case, para 13. Yes, my lord. In the present case, the averment mentioned by the complainant in his examination in chief and factum presented before the court through various exhibited documents very clearly shows the complainant has followed all the legal procedure that do within limitation in order to set the case of prosecution.
So no grievance about that. Then further.
Yes,
Page 1, para 14.
Para 14. According to section 139 of NI Act, the court has to presume that a check was issued by drawer toward discharge of any debt or any liability. However, such presumption is not irrebuttable. Rather, the evidence can be adduced by the defense to obviate the case of presumption. However, the sole burden to rebut the presumption lies entirely the soldier of the accused, unless the case of the complainant itself appears to be improbable and unsustainable in the eye of law. In the present case, nothing appears before the court to disbelieve the case of complainant. Rather, the documentary evidence filed on behalf of the complainant in the form of bounce check 31 in favor of complainant marked as Exhibit 6, check return memo dated though Exola stating the reason of return drawer's signature differs, marked Exhibit 2, demand notice marked Exhibit 3, postal slip dated marked Exhibit 4, courier slip demand notice dated so and so, Exhibit. All the legal and procedural formality have been complied by the complainant before filing the present case. In support of the case, complainant here adduced two eyewitnesses who had seen the transaction of advancing loan in cash to the accused person and giving the of check by accused to the complainant in discharge of the said loan amount. And the testimony of the CW1 complainant of the present case, CW2 and CW3 remained on second during cross-examination and went on to support the case of complainant. In present case, check return memo states the reason for non-payment drawer signature due. But when the statement of the accused are recorded under section 313 CRPC, he has stated that he has given the check as a security check.
Okay. देखिए. Criminal Revision number 313 of 2020. Heard the learned counsel for the parties. The learned counsel for the petitioner submits that although both the courts have returned concurrent findings while convicting the petitioner for offence under section 138 of Negotiable Instruments Act, but the impugned judgments are perverse. The learned on the following grounds. A. No document was brought on record by the complainant to show that he had shown the money advanced to the petitioner in income tax return. He has referred to section 269 SS of Income Tax Act to submit that any amount exceeding 20,000 has to be given only by way of check. The learned counsel has submitted that the capacity to extend money has not been proved by the complainant. The learned counsel submits that the complainant made out a case that a friendly loan was given to the petitioner which was used in gambling.
It did not comply with the will.
Which was used in gambling. The learned counsel submits that the fact that the money was used in gambling by the petitioner the amount so used by the petitioner in gambling cannot be said to be legally enforceable debt. And therefore, the case under section 138 Negotiable Instruments Act was itself not maintainable for bouncing of check in connection with the money which the petitioner had used in gambling. Next point of view. The complainant is in a habit of giving loan and is doing business of money lending without showing his income under the income tax, and 5 different cases against different persons has been instituted by the petitioner. And therefore, the transaction of money which had taken place cannot come within the meaning of legally enforceable debt. The learned counsel for the opposite party has opposed the prayer and has submitted that the learned courts have passed well-reasoned judgment by referring to each and every material on record, and the judgments do not call for any interference in judicial jurisdiction. The learned counsel has also submitted that the learned courts have also considered the presumption under section 139 of Negotiable Instruments Act, and such presumption was never rebutted. उनका submission में 2 चीज़ और लिखिएगा. The evidence of one independent witness has not been properly examined by the court. कौन सा CW?
CW.
CW बताइए.
Yes. Only one independent witness, CW reporter. ये रामनाथ है CW3 my lord.
CW3 has not been properly examined by the court. ये लिख लीजिए. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that the complainant had filed a complaint case against the petitioner under Section 138 of Negotiable Instruments Act, alleging inter alia that they were well known to each other. Both of them were businessmen and had close friendly relationship. It was alleged that taking advantage of the close relationship, the petitioner demanded an amount of rupees 9 lakhs as friendly loan for his business in the month of August 2015, which was duly extended to the petitioner, who assured to return it in 3 months. And in order to return the money, two post-dated checks of rupees 5 lakhs dated 31/12/2015 and the other rupees 4 lakhs dated 30/4/2016 was issued by the petitioner दोनों चेक बाउंस हो गया था
नहीं, एक चेक का
एक ही चेक का केस
The check dated 31/12/2015 was presented and it returned unpaid, and after completing all the legal formalities, the case was instituted. The reason for dishonor of the check was signature did not match. The drawer's signature differs, inverted comma. During the course of arguments, no grievance has been raised by the learned counsel for the petitioner with regard to the timeline prescribed for instituting the case under the provisions of Section 138 of Negotiable Instruments Act. The finding recorded by the learned trial court in paragraph 13 that the complainant had followed all the legal procedure and the case was filed within limitation to set the prosecution in motion is not in dispute. This court further finds that the learned trial court has considered the evidences of all the 3 witnesses. C1 was the complainant and C2 and C3 were the persons who were witness to the advancement of loan to the accused. And C2 and C3 were other 2 witnesses. And they were the witnesses also of the issuance of check by the petitioner to return the money of rupees 9 lakhs. Apart from the fact that they were witnesses to advancement of loan of rupees 9 lakhs. The learned trial court recorded its finding in paragraph 13 to 19 as follows and convicted the petitioner. The learned appellate court has also scrutinized the materials on record and dismissed the appeal. There are concurrent findings of both the courts with regard to the conviction of the petitioner. Although the learned counsel for the petitioner has submitted that the evidence of the independent witness CW3 has not been properly considered, but no further argument has been advanced by the learned counsel for the petitioner with regard to the aforesaid aspect of the matter. This is over and above the fact that in the revision jurisdiction there is no scope for interference in the matter in absence of any perversity. There is no scope for revision court to reappreciate the materials and come to two independent findings, two different findings. So far as the argument of the petitioner that the complainant did not bring any material on record with regard to his income tax return, and to show that the money advanced by the petitioner, the money advanced by the complainant was already disclosed in the income tax is concerned, this court is of the view that the same has no bearing in the matter. There is no such stipulation under section 138 of Negotiable Instruments Act that in order to convict a person under section 138, the amount so advanced should have been shown by the complainant in his income tax. Accordingly, such argument is devoid of any merit, hence rejected. So far as the use of money for gambling is concerned, so far as the argument regarding use of money by gambling is concerned, this court is of the view that the complainant had made out a specific case with regard to extending friendly loan which the petitioner was to use for his business. And ultimate use of money by the petitioner for whatsoever purpose has no bearing in the matter of conviction under section 138 of Negotiable Instruments Act. With regard to the habit of the complainant to give loan is concerned, the same has also no bearing in this case in view of the fact that it was the specific case of the complainant that the money was demanded by the petitioner for his business purpose, and they were well known to each other, and it was extended as a family loan, as a friendly loan. Other cases filed by the complainant has neither been brought on record before the learned courts, nor the same has any bearing in the matter. This court finds that the basic ingredients for offence under section 138 of Negotiable Instruments Act was duly satisfied, and accordingly there is no merit in this case, which is hereby dismissed. Second case, there are two cases. दूसरा केस
दूसरा में वही था जो मेरा हम जिसमें अपोजिट पार्टी कि एफिलेट कोर्ट का पावर है कि तो पिटिशन में कहीं लॉयर नहीं।
कौन सा केस?
सप्लीमेंट्री सप्लीमेंट 7 आ रहा।
उसमें क्या था?
उसमें 386 में क्या हुआ कि कन्विक्शन मेरा क्लाइंट का हुआ तो 386 वो आज आया नहीं, इसने थर्सडे को आई एम सैटिस्फाइड। उसमें क्रूशियल क्वेश्चन है कि जब पनिशमेंट है प्लस सजा भी है प्लस फाइन है, तो क्या एपेलेट कोर्ट सिर्फ फाइन में बदल सकते हैं? दैट इज दिस।
विल हियर इट ऑन थर्सडे। कुछ जजमेंट मिला है तो दे दीजिए।
अभी मिला
पिटिशनर
जो मिला है मैंने उसको वेरीफाई
और थोड़ा छुट्टी में काम
वेटिंग फॉर ऑर्डर्स।
आइडिया बहुत लोड एक्चुअली थोड़ा सा
Under
दौड़
heading-
धूप में आप लोग अच्छे लगते हैं.
Item 8, Criminal Revision 1129 of 2017.
Yes.
Leadership, there was a direction upon me that we have to file an IA for substituted service of notice.
Yes.
And we had also, because the matter has been settled between the parties.
Yes.
And we have brought that on record. But however, since he's not appearing and the bank details had to be brought on record. Leadership, day before yesterday we could contact the client because his number had changed.
That's right.
So 4 weeks time may kindly be granted.
At the request of the counsel for the petitioner, post this case on 18th of October. In the supplementary cause list.
Great.
Item 10, Criminal Revision 196 of 2020.
Yes, petitioner. Yes.
Your Lordship,
The file joint compromise.
no, Your Lordship, one last installment is pending, Your Lordship. It will be done in this September. So,
It was
This
to be-
September.
It was to be paid on 2nd of September, because till date they have not.
Yes. Compromise has failed. Argue the case on merit.
no, Your Lordship, compromise has not been filed yet. But after the last installment, we'll file the joint compromise.
No, there is a petition. Joint compromise is already there. IA number 3708. There is already a joint compromise on record. So compromise has failed. It's good. Very good.
Some money has been paid,
Your Lordship, only the last installment.
Last
is pending.
installment is paid.
Sorry.
The rest of the amount has been paid, Your Lordship. Only the last installment is pending.
So
It will be paid by September, Your Lordship.
by September 24.
Yes, Your Lordship. Then we have.
Okay.
Still
We
we
are
have
posting
the-
it on 1st of October.
Yes.
ठीक है?
ठीक.
The learned counsel for the parties are present. The counsel for the petitioner submits that as per joint compromise, the last installment of money is to be paid by September 24. He submits that the petitioner shall abide by the terms of compromise and submits that the matter be posted on 3rd of October, 3rd October in the supplementary cause list. You will file your affidavit? You will
Yes.
confirm?
Yes,
This is NI Act?
yes.
Yes, sir.
नहीं पेमेंट करेंगे कॉम्प्रोमाइज विल फेल तो जो पैसा दिए हैं वो भी बेकार हो जाएगा
We'll file by.
Under heading for fresh filing, item 11, WPS 3031 of 2022.
Grant of compensate appointment notes. The father of the petitioner died in the year 2001 yours. Then after his wife, the mother of the petitioner has applied for compensate appointment. That was rejected by annexure 4, page 17 yours.
डेट
Dated 10/2/2007.
ऑन व्हाट ग्राउंड
On the ground that his young elder son, namely Mrityunjay, was eligible for compensate appointment, not the wife, and she was only entitled for monetary compensation. She challenged this order in WPS, that is Connection 4548/2007, but it was dismissed for non-prosecution on 30th of October 2017. Then the petitioner, the son, second son, has filed this writ application for grant of compensate appointment.
मच टाइम हैज elapsed we are not going to
Then Lords, annexure 4 का जो alternate इसमें जो दिया जा रहा था, that may be directed to be granted, that the compensate monetary compensation to the wife.
why don't you pay the monetary compensation to the mother
Because she has not taken notes, we will file reply to this.
what reply no reply is required You just pay the monetary compensation. Mother is alive.
Alive.
Mother is
Seek
alive.
instruction on this.
No instruction is required. You just comply. We'll just pass an order to that effect. What instruction? You don't give monetary compensation also.
She had not
You,
taken- we had offered-
if you seek instructions, then I will pass order with interest. You pay this amount. How much time will you need to pay this amount to the mother? We'll ask the mother to approach you. Tell us.
Milords, I am not the counsel on record. It
So
is the
proxy?
case. Yes, Milords.
Very good.
Milords, this is case of Milords Vikas Kumar. Milords, I am only
You will
seeking.
not. Why did you start your argument?
I have not. Milords, I am seeking only 4 weeks time to file counter.
Not required. No counter is required because we are not inclined to grant the relief to the petition.
In terms of
What was
initial-
your age in 2001?
My age, I was minor, Milords, at that point.
Otherwise also not.
All 4 sons were minors at that point.
Milords, one son, Sanjay Kumar, was 21 years old at that point of time.
But he has not come forward.
No, he has not.
WPS number 3031 of 2022. Should I record your presence or should I record your absence?
Vikas Kumar.
Proxy नहीं है. The counsel for the
AC to Vikas
petitioner
Kumar.
is present. Nobody appears on behalf of
Milords,
us.
AC to Vikas Kumar.
नाम दीजिए.
They-
देखिए. Associate counsel to Mr. Vikas Kumar Advocate is present in the court. नाम अपना दीजिए. This writ petition has been filed for the following relief. The learned counsel for the petitioner submits that the father of the petitioner expired on
Expired on 30th.
3/12/2001. 3/12/2001. And the mother applied for compassionate appointment, but the same was declined, and she was held to be entitled for monetary compensation. The order for grant of monetary compensation was passed by the Chief General Manager within bracket B&K bracket close Kargali way back as on 10/2/2007 within bracket annexure 4. The learned counsel submits that thereafter the mother of the petitioner filed a writ petition for payment of monetary compensation, but
Not
this
monetary, we have challenged that
Oh,
result order.
challenging the order and claiming compassionate appointment, but the same was dismissed for non-prosecution in WPS number 4548 of 2007. He submits that now the petitioner has become major and has prayed for compassionate appointment. However, during the course of argument, it is not in dispute that the petitioner was a minor at the time of death of his father, way back in 2001, and as per the writ petition, the petitioner is 27 years of age. तो उस समय कितना साल के रहे होंगे? बहुत छोटे. कितने साल के रहे होंगे?
माइनर था तो 18 से कम था उस समय.
18 से तो कम ही था. Anyways. And when this court expressed that this court is not inclined to allow the prayer for compassionate appointment, the counsel for the petitioner has submitted that appropriate direction may be issued so that the mother of the petitioner may be given the monetary compensation for which order was passed way back in the year 2007. They have submitted that the mother of the petitioner is still alive. But as per his instructions, the same has not been paid to the mother so far. The counsel for the petition or respondents has submitted that he has no instructions in the matter, as no counter affidavit has been filed. However, he submits that in case the monetary compensation has not been paid, there can be no impediment in payment of monetary compensation. And if the mother of the petitioner approaches the Chief General Manager B&K Kargali, the money will be remitted to her if not already remitted. After hearing the learned counsel for the parties and considering the facts and circumstances of this case and the fact that the father of the petitioner expired way back in 2001 and at that point of time the petitioner was a minor and much time has elapsed. Therefore, this court is not inclined to grant the relief of compassionate appointment as prayed for by the petitioner in this writ petition. However, as per the records of this case, the mother of the petitioner was entitled for monetary compensation in lieu of employment, and an order to that effect was passed by Chief General Manager B.N.K. Kadgali as contained in Annexure 4 way back as on 10/2/2007. And this court is of the considered view that if the amount has not yet been paid to the mother of the petitioner, the same should be paid to her without any further delay. For that purpose, the mother of the petitioner may approach the respondent number 4 with her details including bank account, Aadhaar, etc. by filing a representation, and upon such representation, if the amount has not yet been remitted to her, the same be remitted to her within a period of 15 days from the date of representation. This petition is accordingly disposed of.
Passover case from supplementary list, item 3, criminal division 1417 of 2016.
Where is the council? You will decide. इसका बहुत देखिए LCR. आप ही का केस कॉल आउट हुआ. Yesterday you were there ना? आपका नहीं है?
ना मेरा नाम शेखर प्रसाद सिंह है.
वही तो हमको थोड़ा कंफ्यूजन था. Where is Mr. Sanjay Prashad? We'll decide. Like. Forget it. You inform him after the order is passed. Because we have already flashed in the notice board also, and nobody has turned up, so we really can't do anything about it. इसका रिकॉर्ड है ना? Nobody appears on behalf of the petitioner on repeated call. The records have already been received from the concerned court, and the learned counsel for the income tax department is present to assist this court. State has that. State is also there.
State is also there.
Where are they absent?
Yes.
Now let us see. You show us the finding. His main grievance as per the revision petition is that his show cause reply has not been given.
That is there in the ground 3 at page number 8. as
She
well
has
as
also stated that it is compoundable in nature.
yes.
What do you say to that?
Once the cognizance has been taken, and the in that case the SSC loses its chance to file for the application for compounding of the offence.
Okay.
And when it has been decided, it completely goes away from the discretion of the PCCIT to compound the offence, because now it is sub judice.
The grounds raised by the petitioner in the memo of revision are as under quote. The learned counsel appearing on behalf of the Income Tax Department has submitted that as per the grounds raised, the grievance of the petitioner is that his or her reply to the show cause has not been properly considered, and that she had filed an application for compounding, but compounding and during the pendency of the trial, but the trial court did not take that into consideration. The learned counsel for the Income Tax Department has opposed the prayer of the petitioner and has submitted that the learned courts have considered every aspect of the matter, including the show cause reply filed by the petitioner. He has referred to the show cause reply, which was exhibit. It was marked as exhibit 11 and has submitted that the petitioner had tried to, and the petitioner has taken a stand in the show cause reply that she had put thumb impression on blank return forms, and at the instance of Sri Satyavan Roy, and who assured her that proper return will be filed on her behalf. And she hoped that Satyavan Rai will submit the return and documents correctly. Her signature is there, not her thumb impression in the return.
Yes, ma'am. Well, I have written in the counter affidavit also its signature.
The learned counsel for the petitioner, respondent, has submitted that the verification form was duly signed by the petitioner and filing of return is not in dispute. It is a case where the petitioner claimed refund of rupees आपने
संजय प्रसाद ने वो दूसरे कोर्ट में लेक्स में है वो पास हो गए
पास ओवर क्या करेंगे वो तो है ही नहीं कल भी था ये मैटर आज 2-3 बार कॉल हो गया आप है नहीं यहाँ पर
नेक्स्ट वीक के लिए
रिजेक्टेड
तो शॉर्ट पास ओवर कर दिया
कितने बजे
सेकंड हाफ
में बेंच नहीं
1 बजे रख
They have been delaying the process for quite some time.
आज के बाद डिले नहीं है टुडे इज द लास्ट डे they deserve natural justice because we are not with them नहीं आएंगे तो भी ऑर्डर होगा इसीलिए उनको बोलिए कि आ जाए तो बेहतर है नहीं तो क्लाइंट को जवाबदेही हो जाएगा बहुत ज़्यादा है ना आधा ऑर्डर हम लिखा चुके हैं 1 बजे नहीं 1:45 है 1:45 है ठीक है let him have his time don't worry
Item 12 BA 4050 of 2024.
yes petitioner
earlier rejected matter
what is the stage of the case
not
stage
witnesses चल रहे हैं
how many witnesses have been examined
except IO as per the verbal instruction except IO all witnesses have been examined
so it is at the fag end it must be at the fag end yes tell us
pardon me
what is the stage we'll call for the stage
the status report will be called the status is 9 February 2023 initially
we'll call for the status it seems that almost the trial is over how many cases do you have against you
as per the last one report 11 cases but
11 cases
yes Lord as per instruction Lord he has been either acquitted or released on bail so almost cases he has been acquitted in the case in this case also he is not
you have not brought on record
yes Lord that is
ऐसा verbal से
yes 11 cases actually for last 1 year he is in custody and no one is approaching him that's why 395 initially 395 charge sheet has been submitted under section 395 and 396
396
yes not named in the FIR
what is the punishment prescribed
life imprisonment 395
the trial is at fag end isn't it
so on the basis of confession of one co-accused below the name of the petitioner has been transferred and he has been acquitted
trained डकैती
trained cash है घड़ी है वो जो that was never put on
trained
TIP
डकैती how serious it is how serious it is have you been identified
no no TIP was conducted there were occurrences of 2004 he was not named therefore he has been arrested in this case in 2023 not named no TIP on confession he has been transferred in this case and the person who has taken his name has been acquitted in the
This is a supplementary record,
Yes,
isn't it? We'll call for the status of the case. BA number 4050 of 2024. Office is directed to call for the status of the case from the concerned court. The status report should also indicate the likely time in which the trial is to be concluded. The time in which the trial is likely to be concluded. Jenny. Post on 18th. Let this order be communicated.
Six cases as per notice at 12 o'clock. Item 9 CMP 717 of 2019.
Yes, petitioner. What is the CMP for?
This is for restoration of the CMP. Restoration of CMP 318/2007. And that restoration is also for another CMP.
This is for orders. Why is it for orders? Why the case is listed for orders? You have not seen the file.
ये लिमिटेशन के लिए होगा इसमें 136 डेज डिले हुआ है
4 आईए मेडिसिन पेंडिंग है.
There are so many IAs pending.
हाँ IA नंबर 4522 2022 सब्स्टिट्यूशन के लिए तो बाकी आए अधिकांश आए सब्स्टिट्यूशन हो गया नोटिस भी सबका सर्विस हो चुका है अपीयरेंस भी है Paragraph 3, 4, 5, 6 में हमने
Limitation of 136 days. Substitution of OP number 15 and 38.
वो भी हो चुका है
This IA is pending. You have not seen the office note. इतना सारा office note है. You don't see the office note. आप देखिए. आप पहले office note देखिए.
Notices have been served and reported served.
All the persons have been served.
Yes.
आप देख के बताइए. देख के बताइए.
हाँ ठीक.
You just have a look at it. There are so many respondents, so many people dead. We do not know.
Earlier I have seen, but by that time all
You
have
just have a look at it.
services have
Okay, next go.
properly.
Item 18 CMP 306 of 2022.
Yes.
There is story somewhere. I have stated in para 6 and 7. What is the reason?
What is the reason? What is the reason?
My lord, the case was filed, my lord, due to wrong number and date has been mentioned by the oath commissioner. And when the petitioner know, thereafter the oath commissioner period is completed. That's why the defect has not been removed. Page 6 and 7. Para 6 and 7.
The counsel for the parties are present. This petition has been filed for restoration of WPS number 2178 of 2020, which has been dismissed on 13/6/2022 for non-compliance of order dated 9/5/2022. The counsel for the petitioner has submitted that the defect could not be removed as the period of the oath commissioner was over.
Yes.
The learned counsel has also submitted that the writ petition be restored to its original file, and you will take appropriate steps in the writ petition either to get the defect ignored or rectify the defects in the writ petition. Any objection? The learned counsel for the opposite party has no serious objection to the care for this. After hearing the counsel for the party and being satisfied with the cause shown, the order dated 9/5/2022 dismissing the writ petition being WPS number 2178 of 2020. No, the writ petition is the WPS number 2178 of 2020 is restored to its original file. The CLP is accordingly disposed of. Office is directed to place the writ petition before appropriate bench and disposed.
Item 20 CMP 632 of 2022.
Petitioner. Where is the petitioner? Petitioner is absent. Then again he will not remove the defects. Vijay Shankar Prasad. Vijay Shankar Prasad is no more. He is the only counsel in the writ petition. Dikhai jara writ record. CMP number 632 of 2022. It has been reported at bar that the counsel for the petitioner, Mr. Vijay Shankar Prasad, has expired. Office is directed to issue notice to the petitioners through the concerned police station so that the petitioners may take appropriate steps in this case. Post this case on 25th October. Counsel for the state is present.
Item 21 PMP 424 of 2023.
Your Ladyship, this petition has been filed for extension of time to file this supplementary objection in terms of section 9 of the Bihar and Odisha Public Demand Recovery Act.
So what is your ground? Why didn't you comply with the order in time?
Your Ladyship, the order was uploaded much belatedly and it came to the knowledge of the
When
petitioner.
was it uploaded?
It was uploaded Your Ladyship, it came to the knowledge of the petitioner only on 22nd.
We want to know when was it uploaded?
Approximately on 20th March 23, Your Ladyship.
ये read का record. Uploading का date order में लिखा होता है. Did you inspect the record? In all the orders, the date of uploading is mentioned.
It has not been mentioned, Your Ladyship, in order.
was uploaded on 16/3/23. While into abide by the order, it was passed in open court.
It was an inadvertent error, Your Ladyship, but
So please don't make such a statement. Okay?
yes, I extend my apologies.
We will extend it subject to cost. We do not appreciate arguments beyond records.
I extend my apologies because
We'll extend it with cost.
Your Ladyship, it was not mentioned in the uploaded order, so I made the submission.
In uploaded or order, it is never mentioned. It is mentioned in the main order, which is in the records of the case. And every stenographer is under a duty to put the date of uploading. And sufficient time was granted to you. The order was, it is not an ex parte order.
No.
You were supposed to simply file your objection. That is all.
We filed our objections on.
Where is your objection?
Third.
Where is your objection? You have not brought it on record.
Yes, it is not on record.
You have not annexed it.
No.
So, where is your bona fide?
Well, it's we have went to the office of the certificate officer. However, they refused to accept it.
You make a very serious allegation. You file your counter. Who is for the certificate officer?
I am for the state.
You seek instructions from the certificate officer and file your response.
Plus, they refused to accept it, stating that
You have not even annexed it with your petition. That this is the reply which I wanted to file, and they refused to accept it. Where is it?
We'll bring it on.
The warrant of arrest was stayed by this honorable court
Yes.
till 31st of May.
31st of May, and the order was uploaded on 16th of March, and you say you have no idea. Your petition lacks bona fide. What will happen if the certificate officer denies completely?
Yes, we have read
Where is that petition?
this petition. We have not brought on record. We'll bring
Where
it.
is it?
Bring it on.
अब तो warrant of arrest तो हो ही गया होगा ना?
Let's say it was already.
So you face the warrant of arrest, you get arrested. That would be better. And you see, you have filed this case on 10/4/23.
Yes,
Objection was to be filed till 11th of April.
Till 11th of April.
Its objection was to be filed by 23rd
23rd,
March.
sorry.
Reply to the objection was to be filed by 11th.
By 23rd March. That is why you have written that on 22nd March it was uploaded.
Yes, we have written that it came to our knowledge.
So you shut your eyes and nothing will come to your knowledge.
It was an error on our part that we could not.
So okay, let's extend the time, but some cost you have to pay.
That's whatever.
You
No
pay some
reason has
cost.
been assigned, madam. No reason has been assigned to explain the delay. After 23rd, even if...
Just a moment. CMP number 424 of 2020. Counsel for the parties are present. This petition has been filed seeking modification of order dated 1/3/2023 passed by this court in WPC number 2702 of 2013, by which time was granted to the petitioner to file their objection under section 9 before the learned certificate, before the concerned certificate officer on or before 23/3/2023. The counsel for the petitioner has referred to the petition to submit that the order dated 1/3/2023 was uploaded belatedly, which came to his knowledge only on 22/3/2023. The learned counsel for the opposite parties have opposed the prayer and has submitted that the order was dictated in open court and the petitioner was to file his objection under section 9 of the Bihar and Odisha Public Demand Recovery Act, and there could be no reason for non-compliance of the order within the time frame. However, the records of this case, of the writ record, reveal that the order was uploaded on 16/3/2023. And however, this court finds that the order dated 1/3/2023 was uploaded on 16/3/2023 as noted by the concerned stenographer of this court in the order itself. In such circumstances, the stand of the petitioner that it came to his knowledge only on 22/3/2023 is not acceptable to this court on account of two reasons. The order was uploaded on 16/3/2023 and the order was dictated in open court. However, the fact remains that if the petitioners are deprived of filing their objection under section 9, they will certainly suffer irreparable loss and injury. In such circumstances, this court कब तक कर लेंगे? उसके बाद भी ऑर्डर अपलोडिंग का वेट करेंगे?
1 month may be given.
1 month. आपका तो रेडी है ना?
Go
Go and file it.
one small.
It is ready with you.
The petitioner number 1 is in judicial custody. That is why I am asking for 1 month. With regard to certain allegations under GST Act.
At the request of the counsel for the petitioner, the date of filing the objection under section 9 before the concerned certificate officer is extended till 18th of October, subject to payment of cost of rupees 10,000 to be deposited by the petitioner in the office of Jharkhand State Legal Services Authority. No, of High Court Legal Services Committee. The गलत चीज का बहुत ज़्यादा रिपरकशन. Need not tender apology. You tender money.
Association को दे दिया.
हाँ?
Association को दे दिया.
Association को?
Clerk association को दे दिया.
Sorry?
Clerk को दे दिया. Clerk association उसको दे दिया.
Clerk association का नहीं करेंगे. Such that you remember for all times to come. कि record में गलत चीज नहीं बोल सकते. The deposit clerk association, क्या नाम है association का? Clerk association.
Advocate Clerk Association.
Advocate Clerks
हम लिख के
Association.
दे.
बैंक अकाउंट डिटेल है?
हम लिख के दे.
हाँ तो बस उनको आना नहीं पड़ेगा. सारा डिटेल दे दीजिए. At the following details. The proof of deposit of cost be furnished in this record.
Item 25 CMP 839 of 2023.
Registration application due to non-compliance of the entry order. Passed on 9/6/2023 and dismissed on 6/7/2023.
Why didn't you remove the defect? Any reason given?
This has not been marked, my lord, and due to reason that.
You will remove the defect in the writ petition. I will extend the time. I will extend the time till 18th of October. You remove the defects. Is that okay? Have you seen the defects in the writ petition?
Some cost note fee and some there are some typing mistake or something.
So that can be done by 18th. CMP number 839 of 2023. This petition has been filed for restoration of WPS number 4333 of 2020, which was dismissed on 6/7/2022 on account of non-compliance of preemptory order dated 9/6/2022, whereby time was granted to the petitioner to remove the defects in the writ petition. Counsel for the petitioner has submitted that due to inadvertence, the list could not be marked and therefore the defect could not be removed. Being satisfied with the cause shown, the time for removal of defect in WPS number 4333 of 2020, which has been granted by the order dated 9/6/2022, is extended till 18th of October. This petition is accordingly disposed of.
Item 26, CMP 872 of 2023.
Yes, petitioner.
For modification of the order dated 31/1/2023 to 2023, in which Lordship Honorable Court directed 3 month time was given by this Honorable Court to represent before the tribunal, but unfortunately he has not moved. So for further extension of time, 3 months really.
Any objection? The learned counsel for the parties are present. This petition has been filed seeking modification of order dated 31/1/2023, passed by this court in WPC number 4887 up to 2012. To enable to extend the time of filing the petition in terms of order dated 31/1/2023. The learned counsel for the petitioner has submitted that the order was passed by this court, though in favor of the petitioner, in absence of the petitioner. And by the time the petitioner came to know about it, the time had expired. यही आपका काम है.
Time expired करके move नहीं कर पाया.
Counsel for the state has respondents has no serious objection to the prayer for extension of time. After hearing the counsel for the parties and being satisfied with the cause shown by the petitioner, the time for filing the representation in order dated 31/1/2023, passed in the WPC number 4887 of 2012, is extended till 18th of October. हो जाएगा? This petition is accordingly disposed of. Order upload होगा, open court में किए हैं, जाके फाइल करेंगे. Okay? फिर ये मत बोलिएगा कि ऑर्डर नहीं अपलोड हुआ. ये आपके सामने ऑर्डर किए हैं 18th तक.
18th
October.
Item 29, CMP 208 of 2024.
Yes, petitioner.
The defect was that which was not removed. A typed copy of page number 77 was not filed by the clerk due to some mistake of his. We have instructed him, but he could not file the same on that time.
CMP number 208 of 2024. Counsel for the party. Parties are present. This petition has been filed seeking restoration of a petition being WPS number 2385 of 2023, which stood dismissed for default on 22/2/2024 on account of non-compliance of preemptory order dated 6/2/2024. The learned counsel for the petitioner submits that only one defect was remaining to be cured in the writ petition, but due to inadvertence, the same could not be removed. After hearing the counsel for the parties and being satisfied with the cause shown, the time granted to remove the defects in WPS number 2385 of 2023 by order dated 6/2/2024 is extended till 18th of October, right? This petition is accordingly disposed of. नहीं करिएगा फिर से dismiss हो जाएगा. It's a preemptory order. It continues to be preemptory, but you remove it by it.
Very positive.
Item 30, CMP 219 of 2024.
Notice for restoration of our WPS number 5328 of 2023. And it was dismissed because of non-compliance of the order dated 20/2022. According to which I was required to remove the defect by 5/2020.
Why do you say a composite order? We call out every case.
No, that's my fault. From here after, I will not.
It gives a very wrong picture, no? We call out every case and also listen to the counsel. If any defect is to be ignored, we ignore the defect. So you do not say composite order. What do you mean?
I will be moved.
We do not want to overburden our stenographers in repeating the same order in numerous writ petitions which remain defective before this court. Hundreds of writ petitions, isn't it?
But there is only one defect, Lord. I will remove it today itself.
Take care in future. You cannot say composite order.
Why is separate order?
It was a separately dictated,
Separately.
every case separately taken up. But one order was taken. CMP number 219.
Lord, I beg to remove the defect today itself, not only small defect, Lord.
We will give you time today.
Lord.
CMP number 219 of 2024. Counsel for the petitioner submits that this petition has been filed for restoration of WPS number 5328 of 2023, which stood dismissed for non-compliance of order dated 20/2/2024. He submits that due to inadvertence, the defect could not be removed. Considering the submissions, the time for removal of defect in WPS number 5328 of 2023 as granted by the order dated 20/2/2024 is extended till 18th of October. This petition is accordingly disposed. You can do it even now, there is no problem. Writ records are here. The counsel for the petitioner is permitted to remove the defect in the writ petition during the course of the day also.
Item 31, CMP 389 of 2024.
Yes. Your lordship said that the past order on 31/3/4 to issue notice to respondent number 3 and 4 under speed post and ordinary post.
So why didn't you file it?
But it was just filed by mistake, just under registered covered and that
Oh, you have filed it under registered cover?
yes.
CMP number 389 of 2024. Counsel for the parties are present. This petition has been filed for restoration of WPS number 255 of 2023, which stood dismissed on 1/3/2024 due to non-compliance of order dated 28/2/24. Counsel for the petitioner has submitted that instead of filing requisites under ordinary process and speed post, the petitioner had filed the requisite under registered cover. Considering the submissions made, the time granted to comply the order dated 22/2/2024 passed in WPS number 255 of 2023 is extended till 18th October. It will be open to the, that should be sufficient. ये notice सोच रहे थे आपको दे देते, हाँ? It will be open to the petitioner to utilize the notices already furnished in the writ record. The CLP is accordingly disposed of.
Item 33, CMP 660 of 2024.
Yes, petitioner. Who is there? Are you appearing? Yes.
Lordship, there is only one defect of board fee.
For restoration.
The restoration is also defective.
आज फाइल कर देंगे बोर्ड फी ऐसे
Writ में. CMP number 660 of 2024. Counsel for the petitioner submits that this petition has been filed for restoration of writ petition being WPS number 4095 of 2023, which stood dismissed for default on account of non-compliance of order dated 16/5/2024. The learned counsel submits that the only surviving defect is with regard to the court fee, and has submitted that on account of inadvertence, the defects could not be removed. Considering the submissions, the time granted to the petitioner by the order dated 16/5/2024 in WPS number 4095 of 2023 is extended till 18th of October. This petition is accordingly disposed of.
लॉर्डशिप आज फाइल कर देंगे
आपको जब मन फाइल करिए 18 अक्टूबर तक का टाइम है। सारा डिफेक्ट एक बार चेक करके अच्छे से रिमूव कर लीजिए, नहीं तो फिर से DFT हो जाएगा।
Item 36, CMP
कौन है
729
आपके
of
सीनियर?
2024.
Who is your senior?
मिस्टर अनुज कुमार
You are there. You are there in this case.
Yes,
I have
ma'am.
extended the time for removal of defects.
Yes,
You
ma'am.
take the records. By 18th you do it.
only
Ensure
for-
that it is not dismissed again.
Yes, my lord. Within a day, my lord, we'll file the count.
You do it. I have given you time till 18th.
Yes, my lord. Only court.
18th October 2024. 25 तक का टाइम चाहिए.
No, my lord. Within a week.
चल. Yes.
Restoration petition.
हाँ, with regard to
Lord, you WPS 5546/2023. Lord, some defects were there, Lord, so but I filed inspection also, Lord, before I could not this case was dismissed for default.
सेम ऑर्डर कर देते हैं 18 तारीख तक कर
Certainly,
दीजिए।
I will do.
इसमें कोरस्पॉन्डिंग रेट का नंबर है WPS नंबर 5546 of 2023, नॉन कंप्लायंस ऑफ ऑर्डर डेटेड 22/2024. The time is extended in the writ petition till 18th of October.
Item 37, CMP 740 of 2024.
Same story. सही नहीं है आप लोग का ये। सेम ऑर्डर कर दीजिए। रिट पिटिशन का नंबर है WPL 7641 of 2024. The date of order is 17th of May 2020. The time for removal of defects is extended till in this writ petition, right? In the writ petition is extended till 18th of October. CMP disposal.
Okay.
Item 39, CMP 749 of 2024.
Yes, petitioner. Petitioner absent.
39.
Petitioner absent. It's on 18. Council for the state is present. Next. 18 absent है, हम लोग ऐसे ऑर्डर नहीं कर सकते, फिर DFD हो जाएगा. 18th October.
Item 50, CRMP 2155 of 2024.
Absent 18th. Petitioner absent, post on 18th.
Item 51, CRMP 2462 of 2024.
Time is allowed. Till 7. Surrender certificate surrendered on 4/7/2024.
Surrendered on
4/7/24, but did not, I did not receive the surrender certificate, therefore could not file. Only date the discussion. The rest of the difference were removed.
You have got a copy of the surrender certificate by now. The petitioner is in custody.
That is he in custody, madam, from 4/7/2024.
This is revision of which year?
Revision of criminal revision.
23.
23.
It is not of my board.
But his order was not complied.
Revision 23 तो मेरे बोर्ड का
नहीं, लेकिन लॉटरी का ऑर्डर था ना, डिसमिस हुआ माइनर का.
नहीं, वो तो हम कर देंगे, लेकिन फिक्स नहीं कर पाएंगे. आपके क्लाइंट जेल में हैं, so we are concerned about it.
इतना कर दिया जाए कि रिस्टोर कर दिया जाए, वहाँ क्लियर कर.
CRMP number 2462 of 2024. Counsel for the petitioner submits that. This petition has been filed for restoration of criminal revision number 1574 of 23, which stood dismissed for default due to non-compliance of order dated 22/6/24. The learned counsel for the petitioner submits that the petitioner has already surrendered on 4/7/2024, but the surrender certificate could not be filed, and the case has been dismissed for default. Considering that he also submitted that the petitioner is in custody. Considering the submissions, the criminal revision number 1574 of 2023 is restored to its original file. This petition is accordingly disposed of. Next.
Let's look at the BS. I would like to apologize for the last case resolution has heard. Ceded 39.
Has crossed now. I have not dismissed any case.
Your Lordship, it was for restoration. Only one page was missing, because of which
You come on 18. We have fixed it on 18. Next.
Item 52, CRMP 2502 of 2024.
Yes, petitioner. Yes.
This instance will be applied for restoration criminal number 1183 of 2023. Which to dismiss for default on 12/7/2024 for non-compliance of order dated 22/6/2023.
Your discharge petition has been rejected. Criminal revision is CRMP number 2502 of 24. Counsel for the petition submits that this petition has been filed for restoration of criminal revision number 1183 of 2023, which stood dismissed for non-compliance of order dated 22/6/24. the learned counsel submits that due to inadvertence, the defects could not be removed. And he undertakes to remove the defect if time is granted by this court. Considering the submissions, the time for removal of defect which has been granted by the order dated 22/6/2024 in criminal revision number 1183 of 2023 is extended till 18th October. CRMP is accordingly disposed.
Okay.
Item 53, CRMP 2653 of 2024.
Yes, petitioner. Petitioner absent, post on 18th October.
Item 54, CRMP 2680 of 2024.
Petitioner absent, post on 18th October. अब पास ओवर नहीं हो पाएगा, ऑर्डर्स पास ओवर अब अगली वीक आप देख लिए ना, एवरीबडी हैज बीन सर्व्ड.
Now another petition is first IA number 1664. Petition number 12 has died, so
you do something.
I have to. I did. This is.
That's may I make a suggestion? Yes. But there was a second appeal on the rating of 10,000.
Yes, we see there are so many parties, everybody is dying.
Altogether 14 opposite parties, 41 opposite parties are there. Out of them will not.
How many have appeared?
Not, I am representing 3, 4, 10, 11, 12, 18.
We'll do it on 18. There are so many complications in this
And
case.
Lord, this is the third CMP, Lord.
And second appeal है ना, property का dispute क्या करेंगे? We have to see, but unless the notice is served on each one of them, we are not going to restore it.
सब का हो गया.
Everybody has been served notice. सुनिए ना, समीर जी, ऑफिस को बोलिएगा, प्रॉपर ऑफिस नोट बनाइए, किसका नोटिस सर्व्ड है या डीम्ड सर्व्ड है. If anybody is dead, that office note should indicate that such and such person is dead, substitution is pending, not pending, right? Office notes are not being properly prepared. Second appeal है ना, there are so many persons. The whole thing is that if any second appeal is restored without giving notice to the concerned party, then everything will be shit. You understand that? So we have to ensure, पता नहीं चलता, किसी अच्छे senior आदमी को बोलकर इसका, we will get proper office note and then we will ask. Quarter to 1, we have fixed those income tax matters. Yes.
Passover case from supplementary list item 3, Criminal Division 1417 of 2016.
Petitioner is again absent. उनको लिखाई दिए थे आधा, ठीक है. In spite of repeated calls, the counsel for the petitioner is absent. The records have already been received from the concerned court, and this case is being disposed of with the assistance of the counsel appearing on behalf of the Income Tax Department. The perusal of the revision petition revealed that following grounds have been raised in this petition. Counsel for the Income Tax Department has submitted that the grievance of the petitioner in this revision is that the reply to show cause filed by the petitioner has not been properly considered. And further, she claims that before the learned trial court as well as appellate court, she had filed an application for compromise, but the same was not considered. The learned counsel for the Income Tax Department has placed the improved judgments and has also placed the show cause reply filed by the petitioner, which is Exhibit 11, and has submitted that the show cause reply has been duly considered and ignorance of income tax law and procedure cannot be a ground It has also submitted that the provision of section 2278 capital E has been duly considered. The learned counsel has submitted that the matter relates to refund of to claim of refund of 56,912 on the basis of TDS certificate purported to be issued by LIC Chirkunda branch and deduction on account of housing loan, which upon inquiry were found to be incorrect. The learned counsel has also submitted that the show cause reply, in the show cause reply, the signature of the petitioner in the verification form has not been denied, right?
In her show cause notice, she has not denied, but in her statement under section 313 of CRPC, she says that that is not her signature.
Was not denied, but in a statement filed under section, in a statement recorded under section 313, she denied her signature on the verification form. He has submitted that in the show cause reply, she had stated that she had put thumb impression on blank return forms at the instance of Satyaban Roy, but the return is on record, which revealed that she had put her signature in the return. Correct?
Yes, ma'am. And she has also confessed in her reply that she neither is she an LIC agent nor has she taken any housing loan.
She has confessed, and it is not in dispute that she is neither an LIC agent nor she had taken any housing loan, and therefore the details mentioned in the income tax return and her claim for refund was not correct, even according to the petitioner. After hearing the learned counsel appearing on behalf of the Income Tax Department and having gone through the records, this court finds that the income tax return has been exhibited before the court and the Saral form was submitted under the signature of the petitioner, under a signature. However, when show cause notice was issued to the petitioner, the petitioner had taken a stand that she had given thumb impression on blank return forms at the instance of Sri Satyaban Roy, who approached her for filing the returns, and she was assured that the returns will be properly filed along with documents. This court finds that the learned court, by convicting the petitioner, has duly considered the materials on record, including her reply as contained in Exhibit 11. This court finds that the learned courts have considered the materials and found the petitioner guilty. The learned courts have also taken into consideration Section 278 capital E of Income Tax Act, which deals with presumption regarding existence of mental state, culpable mental state. The findings of the learned court are quoted as under. उसका कुछ quotations है यहाँ से, findings आप यहाँ से. Trial court का judgment is in Hindi. You can just take the findings from the appellate court judgment. This court finds that the show cause having been duly considered, the grievance of the petitioner in the division that the show cause has not been properly considered is not correct. So far as with regard to compromise, the learned counsel for the Income Tax Department has submitted that there was no scope of compromise once the trial had commenced. And therefore, such request could not have been accepted by the learned courts. And he has no instructions to accept any kind of compromise from the side of the petitioner. So far as the compromise is concerned, a compromise / compoundable nature of offence is concerned, the counsel for the Income Tax Department has no instructions in the matter, and he has submitted that since the matter was pending before the courts, there was no scope for such consideration, as the trial had already commenced. Moreover, the counsel for the petitioner is also not present before this court to pursue the present case. Considering the totality of facts and circumstances of this case, this court finds no merits in this revision petition, which is accordingly dismissed.
Item 6 is also for the same assessee. The assessment here is different.
Equivalent. Just one by one.
Item 4, Criminal Division 1485 of 2016.
Same counsel. He is
Same
the
counsel.
husband of the SSC, Nimai Chandra Ghosh.
इसका LCR. What is the allegation? And what is his reply?
He is also playing the same ground that the compromise petition was not considered, and at the same time, the ground third also. General government's money.
I just wanted to see his reply. The reply for the show cause reply. He filed a show cause reply. Did he file a show cause reply before the authority?
I have no information with regard to that as far as the records that are available.
Show cause reply is there. He has put his signature in English and he has said that he is an uneducated, illiterate, no income, no knowledge of income tax rules, etc. इनका जो show cause reply है ना, उसमें भी उसको quote कर देंगे. We'll quote the show cause reply furnished by him. That will be best. Show cause for initiation of proceedings.
But in his statement under 313 of CRPC, he has admitted his signature on verification.
Yes, yes, it's
Claiming to be falsely implicated though.
He did not respond to his show cause reply. He did not respond to show cause. Perhaps he has given an intimation that he has signed on blank papers after filing the returns.
But he has admitted before the court.
Yes, yes.
That is his signature.
इसमें भी लिखिए. The counsel for the petitioner is absent in spite of repeated calls. Distribution has been filed. Against contrary findings recorded by the learned courts in connection with conviction of the petitioner under section 277 of Income Tax Act. बाकी डिटेल ले लीजिएगा conviction जो भी है. The grounds raised by the petitioner in the revision petition are as under. The learned counsel for the respondent Income Tax Department while opposing the prayer of the petitioner has submitted that the learned courts have considered the materials on record and there are concurrent findings with regard to the petitioner who had filed a false refund claim of rupees 35,875 for the assessment year 2003-4 on the strength of forged TDS certificate and housing loan and claim regarding housing loan. He has not made any grievance regarding compromise, has he?
No, madam.
There is no grievance regarding compromise in this case.
The only defense that he is playing is that he has been implicated.
The learned counsel has submitted that the only defense which the petitioner has taken before the court is regarding false implication.
Yes, madam. While simultaneously admitting his signature.
And simultaneously he has admitted his signature on the verification of the returns filed. After hearing the learned counsel for the petitioner, the learned counsel for the income tax department, and upon going through the records this court finds that the specific case of the income tax department was that the petitioner, being an employee of Baramuri OCP ECL Mugma area Chirkunda district Dhanbad, being a dumper operator deriving income from salaries, was an SSC within the meaning of Income Tax Act, and he filed his return on 28/7/2003 by putting signature on the verification portion of the return along with TDS certificate and other documents, and claimed a refund of rupees 35,875 on the basis of TDS certificate in Form 16 purportedly issued on 25/2003 by the Senior Accounts Officer Burma Muri OCP ECN Mukma area Chirkunda, and also on the basis of loss from house property on account of interest paid on housing loan amounting to rupees 28,420. The claim of refund was made as excess deduction of tax at source. On verification and inquiry from the concerned office as well as bank, it was found that neither TDS certificate as submitted by the petitioner along with the return was issued by the said officer, nor the housing loan was granted to the petitioner by the bank, and thus the claim of the petitioner was based on fake and false documents, and thus no refund was granted it has been also mentioned that the petitioner, in reply to the show cause notice as to why a prosecution under section 277 of Income Tax Act be not issued, has tried to shift the burden on one Satyavan Roy, an office assistant of Baramudi OCP ECL Mugma area Chichkunda. The prosecution was launched under section 277 of Income Tax Act. After taking due sanction for initiation of prosecution, the petitioner appeared and thereafter witnesses were produced on behalf of the complainant who were duly examined. The witnesses were also cross-examined by the petitioner, and the statement of the petitioner was recorded under section 313 of CRPC on 5/10/2013, wherein he denied the evidences available on record. The prosecution had filed an application on 18/11/23 to reopen the evidence, which was duly reopened by the order dated 16/2/2015 on account of apparent mistake in recording of evidence. The PW2 was recalled, and after cross-examination of the witness, the prosecution evidence was once again closed on 27/4/2015, and the statement of the petitioner was once again recorded under section 313 of CRPC. The case of the defense was on total denial, ignorance, and illiteracy. However, the defense did not lead any evidence. The learned trial court, after considering the materials on record, has considered the entire materials on record by paragraph 9 of the trial court judgment. Has recorded its finding, para 31 से bottom से है. Para page 39. The learned court considered every argument of the petitioner and rejected all of them and passed a detailed order convicting the petitioner. And held that the petitioner had consciously furnished wrong statement, knowing or at least having reason to believe it to be false, and committed offence under section 277 of Income Tax Act. the provision of section 278 capital E was also taken into consideration. The appellate court has also considered the materials on record and recorded, and by upholding the conviction of the petitioner as held in para 21 as under. This court has gone through both the impugn judgments and also has gone through the records as received from the concerned court. And finds that the finds that by the exhibit 15 by 1, the petitioner had taken a specific stand that one Satyavan Ray, also an employee of Bonu open caste area, who deals with affairs of accounts had taken signature of the petitioner and his wife Sulochana Devi on several income tax forms and also blank papers. And he claimed himself to be illiterate and uneducated. Although he had duly signed in English on the said document. He has put his signature in English. This court finds that the learned courts have duly considered the materials on record and there is no scope for the appreciation of materials and coming to a different finding, and accordingly finds no merit in this petition, which is accordingly hereby dismissed. These are two. What about the two rest? One is Sulochana Devi, same story.
Sulochana Devi, same story. The different assessment here, different amount.
That's right. But her reply is the same.
The reply is the same. Nimai Chandra goes different assessment here, then different amount.
Which one?
The next matter in the item list.
That is Sulochana Devi.
That is Nimai Chandra Ghosh.
This petitioner.
Yes, ma'am.
Okay, लाइए जरा. Just. इसको देखना. This is Nimai Chandra Ghosh. Yes, revision 1496.
Certainly.
Let me just see his show cause. That is the most important document. Did he file his show cause reply in this case?
No, my lady, there's no reference of any such reply even in the judgment itself.
It appears that there is no show cause.
Yes, on file.
And in 313 he denied.
It also did not deny.
He
did not deny.
He did not deny his signature in 313.
No, my lady, that is admitted again in the para.
You see, in absence of the counsel for the petitioner, we will not decide the case in haste. Right? He is not there. It is already.
My lady may take into account para 4 of the judgment, where there is a submission to that effect. Appellate court judgment. That is a submission made by the Department of Income Tax itself.
Yes. Para 4 of the appellate court judgment?
Yes, sir. That is a submission of the department, the income tax department, the counsel for it.
Please take us to his submissions. Right, that is more important. Paragraph 4.
Yes.
We'll check his 313. He has not denied it. नहीं बता सकते खाली बोल।
Yes, ma'am.
And what was his argument?
Argument was that the reply
Before the appellate court, let us see what was his argument. What was his case before the appellate court?
the submissions that has been considered by the court below starts from para 9 in the finding itself. Terming the conviction barred in law.
He has tried to deny his signature before the appellate court.
But based on the evidence of the trial court, there has been a submission to that effect made.
That's right.
That aspect has not been dealt by the appellate court. But in the other judgment, they had dealt it, and where there was a similar submissions that he had accepted his signature under 313 statement.
That's right. The findings are there. These discussions are there. para 17 and 18
Yes,
of the appellate court judgment.
Also, this is covered by the Mangatram Narota judgment.
Mangatram.
Yes, ma'am. Para 10 that we are relying upon, that his conduct was there. And in this also, there is no submission to that effect that has been made, that he is denying the signature. The statements are on record under 313.
Yes, he says, pata nahi. He is not denying, he is not.
Maybe the wisdom has prevailed after the trial in the first case that he should not have said so.
In this case also, he has taken the plea of signature in blank pages. This is a slightly different kind of record. This is slightly different. We'll post it for Wednesday.
Okay.
That would be better.
Sorry. But item number 6 is identically the same matter. Sulochana Devi.
Sulochana Devi, we have seen that. Sulochana Devi stands 6th. इसका दिखाइए LCR. The grounds are also perhaps the same. Grounds are also copy paste.
Exactly.
And here we have a reply. Show cause, exhibit number.
In her reply, she has accepted the fact that she was advised to do so.
I just wanted to. Here also she is saying same answer, same, identical. These are absolutely identical. And return, I want to see. She had put her signature. Here also she had put her signature on
Yes,
it.
sir.
Right? वो एक सुलोचना देवी वाला लिखा है. This is absolutely same. Right? This also stands dismissed. ये सुलोचना देवी. Same, absolutely. Everything is same.
Only the refund amount is different.
Yes, that we will take care. One matter of this Nimai Chandra Ghosh.
Yes, sir.
It's slightly different. We'll post it on Wednesday.
18.
Item number 16, Your Lordship. If it be posted for Wednesday, if possible.
16 is what?
16. I have filed application for suspension of sentence during the pendency of revision application. Also. Out of 1 year, he has already in custody. He's already in custody since more than 4.5 years, 4.5 months. 138 NIR case, Your Lordship. The legal point is there, fully covered by Your
I will
Lordship.
give you a suspension of sentence. You deposit the amount. You
There is-
deposit the amount before the registrar general. It is suspension of sentence or it's exemption from surrender.
No suspension. He is in custody.
नहीं, इसको release करना है.
16. CL number 16.
Other side has
No,
appeared.
first time it has come, Your Lordship. What has happened
Just
was
a
the
moment.
matter-
Just a moment. State है इसमें आप
Serial number 6, I am for the state.
16 for
16. 16 delivered.
Yes, your ladyship. I am asking for the state.
He is in custody.
Yes. 24/4/2024, he was taken in custody, Your Lordship.
He was taken into custody on
24/4/2024. Actually, the matter was restored, Your Lordship. On the want of the surrender certificate, Your Lordship, it got dismissed. The affair was restored, Your Lordship.
you have filed fresh application for bail.
Sorry?
Have you filed fresh application?
Yes, IA has been filed, Your Lordship.
IA number?
IA number 9977 of 2024.
It's not on record.
But it's on board, Your Lordship.
It's not on record. We do not know. But IA is not there on record. Otherwise, we would have passed the order today. It will come on next Friday.
If possible, on Wednesday, Your Lordship. If possible.
Like a tied up matter.
साढ़े चार महीना हो गया.
Malok, item number 21, madam. Malok, they asked me to furnish the bank account details of the advocate.
Yes.
I've sent an email.
email to?
Email to the court number. This court.
आप forward कर देंगे. email आया है.
की?
उनका bank account details का. Yes,
My only request is that serial number 35 may be fixed for next week, Your Lordship.
it will be. All the cases are coming on next week. Next Friday, these matters will be there on board. State is not there in your case.
No, Your Lordship.
Madam, there is a contempt petition, madam, pending.
On
It is
next-
the serial number 34.
On next
So
Friday,
it has been filed, but
on
they are
next
not-
Friday, we will just, like today, we have notified all the restoration matters.
Top of the file, my lordship, maybe kindly allow. Top of the file, my lordship.
Just, it is not possible. We will just give a notice for contempt matters on next Friday.
My lordship, I will.
अगले Friday को ना contempt का matters का notice दे. We will give a notice for contempt. These restoration matters were pending, so therefore.
I understand.